Good evening, ladies and gentlemen. First of all, may I say that I'm absolutely delighted to be here this evening to officially open the first of a series of public seminars which will be presented by the Centre for Criminal Justice and Human Rights Faculty of Law here in Cork. And I would like to thank Professor Paul Giller for inviting me to UCC. And as Ed said in his introduction, even though I come from Sligo and live in Sligo, I have a close affinity with Cork, as one of my daughters is a graduate from the Faculty of Law here in Cork. And I have very many happy memories of crossing and recrossing the Lee and getting gloriously lost each time I crossed it. This evening's seminar will address the issue of mental health and human rights, and so provides a forum for discussion on some of the key human rights issues that arise from medical and legal practitioners in implementing the Mental Health Act 2001. It also provides an opportunity for debate on mental health issues that are a matter of public interest and concern. Recently, there has been great change within the mental health services in Ireland, with the launch of a Vision for Change, the report of the Expert Group on Mental Health Policy in January 2006, and the full implementation of the Mental Health Act 2001 from the 1st of November 2006. A Vision for Change provides a framework for action to develop a modern, high-quality mental health service over the next 7 to 10 years. It proposes a holistic view of mental illness and recommends an integrated, multidisciplinary approach to addressing the biological, psychological and social factors that contribute to mental health problems. The future direction and delivery of all aspects of our mental health services are covered in the report. I am pleased that the Government is very committed to the full implementation of a Vision for Change and has accepted the report as the basis for the future development of our mental health services. The enactment of the Mental Health Act 2001 was a significant milestone in the modernisation of mental health care in our country. The purpose of the Act is twofold. Firstly, it provides a modern framework within which people who are mentally disordered and who need treatment or protection, either in their own interest or in the interest of others, can be cared for and treated. In this regard, the Act brings our legislation in relation to the detention of mentally disordered patients into conformity with the European Convention on the Protection of Human Rights and Fundamental Freedoms. The second purpose of the Act is to put in place mechanisms by which the standards of care and treatment in our mental health services can be monitored, inspected and regulated. Sections 1 to 5, 7 and 31 to 55 of the Mental Health Act 2001 were commenced in April 2002. These involve the establishment of the Mental Health Commission to promote, encourage and foster the establishment and maintenance of high standards and best practice in the delivery of mental health services, and to protect the interests of people detained under the 2001 Act. It also provided for the establishment of the Office of the Inspector of Mental Health Services, replacing the former Inspector of Mental Hospitals. The remaining provisions of the Act were commenced on the 1st of November 2006. This included the establishment of mental health tribunals under the auspices of the Mental Health Commission. The tribunals will conduct a review of each decision by a consultant psychiatrist to detain a patient on an involuntary basis or to extend the duration of such detention. The review will be independent, automatic, and must be completed within 21 days of the detention or extension order being signed. Regulations setting out minimum standards for centres in relation to the care of residents and the provision of adequate and suitable accommodation were introduced from the 1st of November 2006. Compliance with these regulations will be monitored by the Inspector of Mental Health Services. The Department of Health and Children, the HSE and the Mental Health Commission worked closely together to ensure the successful implementation of the Act. The HSE established a national steering group supported by a liaison team to prepare for the full implementation of the Act. These groups work closely with mental health service managers, clinicians and service users to ensure a smooth transition to the new regime. The HSE also convened a working group to develop a proposal for a framework to ensure that second opinions would be sought in a fashion that was independent and seen to be independent. Another useful development was the launch by the Mental Health Commission of a quality framework for mental health services in 2007, which will contribute to the development of a service user-centred mental health service in line with the recommendations in a vision for change. It has also developed guidance in relation to the use of ECT, the use of seclusion, the use of restraint and the admission of children under the Mental Health Act 2001. This Act required that a review of the operation of the Act be carried out within 5 years of its establishment day. That review was undertaken by the Department of Health and Children, and a report of the findings and conclusions was laid before the Houses of the Oireachtas in May of this year. The report recommended a small number of amendments to the Act, and work has since commenced on the drafting of those amendments. However, it must be said that the limited time frame for the review did not allow for a comprehensive review, as the full provisions of the Act have only been in operation since last November. In many instances, it was just too early to reach firm conclusions regarding the operation of the Act. Therefore, the report recommended that a more detailed review of the Act be undertaken by the Department within 5 years of the full implementation, that is, on or before the 1st of November 2011. It is my belief that the review of mental health legislation will be an ongoing process and may need to be revisited in the context of any proposed new capacity legislation or indeed other developments. In addition, the Act must be monitored on an ongoing basis by my department in the context of legal challenges and court judgments. I am sure that everyone here will agree that the full implementation of the Mental Health Act since November the 1st last is a very welcome development, as it provides much needed protection to patients who are involuntarily detained. In conclusion, ladies and gentlemen, I would like to thank everyone involved in the organisation of this seminar this evening. It is commendable that debate and discussion is generated around such an important human issue, and I would like to stress the Government's commitment to the continued development of our mental health services. I am confident that we can build on the substantial progress to date to bring about a mental health service worthy of our country in the 21st century. And I must say that I look forward to hearing the very distinguished speakers that are lined up after me.